Hoping to reduce crime, the Act of 1975 was passed, which restricted residents from owning handguns, except for those who own a firearm before 1975 or held by active or retired law enforcement officers. The law required that rifles and shotguns be kept unloaded and disassembled or bound by a trigger lock. Dick Heller was a local police officer in D.C. Wanting to bring a gun home, he applied for an application, but he was denied. Heller sued the District of Columbia for violating his Second Amendment right. The district court denied Heller's complaint due to the fact that the Second Amendment does not create an individual right to gun ownership, unrelated to service in an organized militia, such as the National Guard. While the Court of Appeal found out the Second Amendment does create an individual right to gun ownership and reversed the lower court's decision. Heading to the Supreme Court, in a 5-4 decision, the Supreme Court held the District Court of Columbia restricting Heller's possession of a firearm in his home, violating his Second Amendment right. Justice Liska, writing for the majority, said that the Second Amendment protects Heller's right to possess a firearm, even if it is unconnected with service in the militia. He spoke about how the Second Amendment reference for a well-ordered militia was only an introductory clause, indicating that the Second Amendment's purpose shouldn't limit someone to bear arms. The majority did allow states to be free to regulate who is allowed to own a gun in order to address safety concerns. The overall court found out the District of Columbia's views on gun ownerships to be overly broad and deemed it unconstitutional.